sometimes it's good to come back to earth here a little bit. We're talking around the issue. Ms. Higgins, I wonder if you would do us all the favor of saying specifically in fairly simple terms that those of us that are not lawyers can understand, what does this bill actually do?
Thank you, Mr. Chairman. Basically, this bill, it does a couple things. First of all, what you said is the reason we're addressing this sex-selective abortion in this PRENDA bill, the importance of addressing that, is that it's taking a holistic view. This is the most lethal form of sex discrimination that's practiced globally and in the United States. It has to be addressed. Not only am I saying this, but it's something that we've seen former Secretary of State Hillary Clinton say, that we as the U.S. must lead the way to promote women's rights and women's equality in reference to infanticide and sex-selective abortions. Nabucco Uribe, who's the director of the UN Population Fund on Asia and Pacific Regional Office, said we have to give priority to programs like PRENDA that foster norms. She didn't say like PRENDA, but that's my statement there. That foster norms in an attitude of zero tolerance for discrimination such as prenatal sex selection. Gender equality is at the very heart of each country's successful development. Zero tolerance of sex discrimination necessarily involves banning the practice of sex-selective abortion. The government has a compelling interest in protecting anyone, whether it's male or female, from any instance of sex discrimination. That's a compelling interest. And we know that a compelling interest would require that the government have an exceedingly persuasive justification to survive constitutional scrutiny. Whereas in abortion jurisprudence, you don't even get to the fundamental rights language, but you do in sex selection because it amounts to discrimination. And we see that in the Civil Rights Act. The Civil Rights Act was basically also applied to private individuals who discriminate. So it's in fact a very important government interest. It's a compelling interest. And when we say that PRENDA is not necessary, we're saying it's not necessary here because we don't have that many sex-selective abortions. Well, it happens here. So what PRENDA does is eliminate that practice. What we're saying is there are no tolerable levels of lethal sex discrimination against girls. There is no tolerable level. Whether it's 1 or 1 million, it's not acceptable. The 14th Amendment guarantees everyone equal protection under the law. That is a compelling government interest that we must protect. We must take a holistic view, and it includes banning sex-selective abortion. Otherwise, we can't be a moral authority overseas and tell people they can't do it if we do. So the second thing PRENDA does, I think that's important, is it allows women, and we know there are instances, documented instances of women in communities around this country in the United States who are coerced into having sex-selective abortions against their will. So what PRENDA does, it allows that woman an out. It allows them a civil remedy against anyone who's coerced them to have an abortion against their will based on the reasons of sex selection. So it allows them to, it empowers women to know that the government stands behind them and protecting them from this practice. So I think those are the two main things PRENDA does, and I think that they're justified under the Constitution.